I will start out with Dean Rachel Barkow, who is at the New York University School of Law, and she's a member of the U.S. Sentencing Commission. Was. And in some learned circles, her name is on short list for the Supreme Court, I read. So it's a pleasure to have. Maybe she didn't know that, but that's what they said on the information that I read about her. So I'm grateful and honored to be here with her. Then we have Professor John Hagan, research professor at the American Bar Foundation, and John D. MacArthur Professor of Sociology and Law at Northwestern University. And Professor Hagan has done tremendous work and conducted extensive research in this general topic of mass incarceration. And lastly, and it's an honor to be here with him. And lastly, we have Mr. Edward Yarbrough, a partner at Bone McAllister Norton PLLC, right here all the way down across on the other side of town in Nashville. So we thank him so much for being here. It is an honor. And he will share with us his experience as the defense attorney for Cyntoia Brown, and he will give you more information and go over the events that he went through as a part of that defense team. So we're happy to have these panelists here. I'm glad to have everyone of you here. And so we will begin because our panelists have presentations, PowerPoint. Everybody say, ooh. So we will start with Professor Hagan. Professor Hagan.
Thank you. I hope you can hear me. I'm having a little trouble with my voice today, but let me know if I'm not speaking loud enough. So I'm going to talk about a little bit different aspect of the issue that we're concerned with today, criminal justice reform, focusing particularly on the impact of parents being incarcerated on their children and how this varies across the United States. And the first point I want to make is that, of course, we're encouraged that we're finally getting some reductions in levels of incarceration in the United States, and this is an extraordinarily important phenomenon. We kind of think of ourselves as having bent the curve, and we're looking forward to that curve coming down. We had a long run up in incarceration, and unfortunately, though, it's going to take a long time to unwind this high level of incarceration that we have in the United States. And some of the recent estimates have argued that it's going to take upwards of somewhere till around 2100 to actually cut the rate of incarceration, the level of incarceration in half in this country. So that's like 80 years from now. And that's a long time. And so we're going to be dealing with the consequences of incarceration for a considerable amount of time. There's extraordinary variation across the United States in the way in which things are unwinding. In particular, there are some of the states, and some of them are large states like New York and California and Texas, that are making some real progress in terms of reductions in incarceration, and other states are as well. But on the bottom of this bar graph, what you're seeing is that there are even some states today that are still increasing their levels of incarceration. So there's this tremendous variation in what's going on across this country, and all of you are very aware of that, I think, so that as we have these kinds of reforms at the federal level, we also have to be thinking about what's going on in the rest of the country. And that's essentially what is the main focus of our work at the moment. This just gives you, again, a sense of how spread out the different levels of reductions and some increases in incarceration are occurring. I believe Nebraska is one of the states that's having still some increase, and there are others as well. Now, in my research, what we're particularly concerned with is the high proportion of inmates who are parents. Something like half of all adult prisoners in the United States are parents. A very high proportion of women who are in prison have children. But somewhere upwards of around half of the men do as well. And since men predominate, of course, in terms of incarceration in America, that's what makes this sort of balance out in the way it does. We're particularly interested in the impact of this incarceration. This line graph is just to simply give you an idea that not only are the number of parents in prison, not only has that been increasing, over time, but because many of these individuals have more than one child and often several children, the actual number of children involved is very high, getting upwards towards the level of 3 million children across the United States who have parents in prison at any particular time. The research that we're doing is based on a national longitudinal study of about 10,000 adolescents who have been tracked since 1995 and up until the recent latest round of this research. These individuals have been tracked 5 different times to be re-interviewed and see what's happening in their lives. And there are all sorts of questions involved in this longitudinal study. And fortunately, some of those questions that we've been involved in designing have to do with incarceration of the parents and then the impact on the children who are the subjects of this research. So this gives you some idea of sort of how this study maps on to the rise of incarceration in the United States and the recent beginnings of a decline that we hope will continue. This research began, as I've indicated, in about 1995, when the average youth involved in the study was about 15 years of age, some variation around that, but on average about 15 years of age. And they've now been tracked for more than 20 years. So it's sort of an interesting time for this research because back then no one knew what would happen with these kids, how their lives would turn out, but now we know. This has been going on. Our rising levels of incarceration have gone on for such a long time, and this tracking has gone on for enough time that we're beginning to now know what's actually happening. And to give you some sense of how this plays out in these data, there are about 10,000 of these youth. Among the African American respondents, adolescents, when they began in the study, about almost 25% have a father who's been incarcerated. And the numbers go down for Hispanic, Latinx groups, and for whites down to around 13%. But these are high levels. These are substantial. And in a sample of this size, it allows us to draw some fairly conclusive ideas about how things are turning out for these now young adults. Of course, the famous Supreme Court Justice Louis Brandeis talked about this range of variation across states that I began this discussion with and talked about this as kind of being an opportunity. He talked about laboratories of democracy, and states could actually exercise this opportunity to engage in their own innovations, and you've been hearing about some of those innovations today. So we can look across these states and get some idea of how things are turning out. What we're particularly interested in at the moment is in how the level of investment in families and their children is impacting on their life outcomes. Do states that provide a lot of welfare and educational support, does that produce better consequences for these children than states who provide relatively little support of this kind? And we look at quite a range of different kinds, different kinds of support that they might receive, all the way from lunch programs in the schools to support for parents who are lacking support in other ways, unemployment insurance, primary school programs, Medicaid, all sorts of things. And we actually have tried to come up with some indication then of the level of actual support that's occurring in particular states and how that varies across this country. Now, we were particularly interested, because we've been able to do this now for some time, we're interested in looking at how the educational life course has turned out for these youth. Actually, today, about almost 90% of all adolescents who get to high school finish high school. So the real sort of crucial dividing point in our society today is actually beyond high school. It's at the college level. So we actually had the opportunity, because these are now individuals in their late 20s and early 30s, to look at whether they've been able to complete college. And we're able to look at a number of different factors. First of all, we're interested in what difference does it make if your father's incarcerated? But we're also interested in some of the consequences of having a father incarcerated. Children of incarcerated parents tend to be lower in terms of verbal readiness. They're more likely to be retained in primary school. And so we're able to look at a number of different factors and how they play out. We look at a lot of different variables. I won't go into this in any detail, just to give you some sense that these outcomes that I'm going to talk about control for a lot of differences among these youth along other dimensions. And I'm just going to show you a couple of final bar graphs that give you an idea of how differently things turn out across different kinds of states in this country. So for example, we're starting here with rates of college graduation, and we're looking at youth who have parents who have or have not been incarcerated. And we're looking at states that are in the top quartile in terms of investing in these youth, in terms of the support programs that I mentioned earlier, and the bottom quartile of states in terms of level of investment. So on the left side of this bar graph, you're seeing that children who don't have a parent incarcerated, if you're in a state where a lot of investment is being made in terms of support for children and families, you get to up to levels of like 40% of college graduation among the youth in these states. And about half this in states that are investing relatively little in comparison in the support of families and children. On the right-hand side of the bar graph, you're looking at children whose fathers have been incarcerated. And what you're seeing in the far right bar is that up to 25% of these children of incarcerated fathers who are in states that are providing a lot of support for their families are actually getting to the point of graduating from college, whereas it's more like on the order of 10% in states with low levels of support. And then just two other bar graphs I'll show. One has to do with being retained or held back in school. Again, we're seeing in the final bar that up to 20% in the high support states of these children with an incarcerated father are getting to level of college graduation, much lower in low investment states. And similarly, if we look at verbal readiness, as these youth are coming into schools, tested early on in this longitudinal study, then we look later on in terms of them getting through school. Even those who have low levels of verbal readiness early on in their educational careers, upwards of 13%, are graduating from college. Now, all of these factors are linked together, as I mentioned in the beginning. The youth who have parents incarcerated are more likely to have problems with verbal readiness, more likely to be held back in school. So quickly, what we're trying to show is that, of course, children are innocent of the crimes of their parents, yet a great deal of variation in how their lives will turn out. That states that differ in levels of investment have a big impact in terms of the amount of inclusionary support that they provide. Together, there's a combination then of the effects of having an incarcerated father and the effects of what kind of state you're growing up in. And the good news is where the state investment is high, these youth are doing relatively well, not as well as children of parents who haven't been in prison, but getting up there in terms of educational achievement. And a lot of this has to do with verbal readiness, being held back in school, getting the kind of support that's necessary to deal with those problems in the earlier years of education. The bad news, on the other hand, is that in states that don't invest so highly in families and children in terms of educational programming, things are not looking so good. And in a sense, these children are really doubly disadvantaged. They're disadvantaged, first of all, by having a parent who goes to prison or jail, and they're disadvantaged, secondly, by being in a state that's not investing in their families and in their educational outcomes. So I'll stop there and hopefully maybe have a chance to say more later. Thank you.
Thank you, Professor Hagan. And I'm glad that we started with Professor Hagan because he has given us the context in which the consequences of all this mass incarceration really affects the family. And so it gives us a buildup to our topic here, mass incarceration and the First Step Act. We know that the United States, as some of the other panelists and as you as criminal justice practitioners know, is one of the highest incarcerators in the world. We're number 11. And above us are individual states such as Louisiana, Alabama, Mississippi, Oklahoma. And so we know that this is truly a uniquely American crisis, as everyone in this room knows. So I want to move from the direct consequences of what the mass incarceration does to the family and talk more about pre-trial detention and sentencing in mass incarceration. The First Step Act was a move towards trying to address the mass incarceration phenomena in the United States on behalf of Congress. Congress, in a bipartisan effort, on December 12th or so, 2018, President Trump did sign the First Step Act into law, which has many provisions in it that were intended or are intended to reduce those incarceration rates for nonviolent offenders. However, we know that as we talk about the First Step Act in the federal context, we can't talk about mass incarceration without talking about it in the state context to really have an impact on the rates of incarceration in our country. And so Professor Hagan's opening was a great way to segue into Dean Barkow's presentation, and I will turn it over to her.
Great, can you hear me okay? Yep,
Yeah.
okay. Thanks very much. What I thought I would do is address two parts of the title of this panel. So mass incarceration, but also some lessons we can learn from the First Step Act. And I think one key thing to keep in mind when you're thinking about the politics behind mass incarceration is I think there's an underlying assumption by our political leaders and by the voting public that longer sentences will make us safer, that putting more people behind bars is good for public safety. And so I want to start by showing the evidence that cuts against that and how important it is to try to get some of that into our political discourse. So just briefly by way of background, I think if there's a conventional wisdom among the public, it's that let's lock as many people up as possible, even pre-trial. Why is someone out on bail? And if they see a news story that someone's committed a crime while they've been released, the thought is, why did that happen? That's a public safety risk. But what we don't get a lot of information on is what's the public safety risk of detaining a lot of people pre-trial. So first of all, for those of you who don't know, this is kind of an overview of who's incarcerated in the United States, and you can see a huge chunk of people are in our local jails. So, it's roughly in the 600,000 range. And most of those people are there pre-trial. But a lot of them are there post-conviction for misdemeanors. But big chunk of them are there pre-trial. And one thing we might ask ourselves is, what does it mean if we decide to make the decision to put people to incarcerate somebody before a trial? So if you think about the population, which we've heard a lot about today, what that population of folks looks like, these are people living at the margins. So even if you just detain them a couple days, it's likely to be incredibly disruptive to the already marginal existence that they are living. So if they have a job, they're likely to lose it. If they've figured out some kind of child care arrangement, that may upend it. They may lose custody of their children just being incarcerated for a couple days. So it shouldn't really be that surprising for us to realize that if you just detain somebody pre-trial, holding everything else, their crime constant, their criminal history constant, just detaining them before they go to trial makes them more likely to commit crimes later. And that's something I think that gets lost in our public debate about this. And if you want to know further details about that, you can see that there's about a 30% increase in felonies and about a 20% increase in misdemeanors. And so I just wanted to start off, although the First Step Act doesn't do anything on the pretrial front, I think it's going to be emblematic of this larger problem that's going to assume longer sentences are better, contrary to research that we have about that. And I think that is a political dysfunction that for us to tackle mass incarceration, we need to come up with some institutional ways to counteract that, to get the system to recognize that that's a big issue. So let's turn to sentencing now and think about some key things that we know about deterrence first. It matters far more for whether or not someone's thinking about committing a crime that they think they're going to get caught than does the length of the sentence once they get caught. Sure, it's going to make a difference if the risk is 1 day versus 30 years. But when we're talking about some of the changes in the First Step Act, 15 years versus 20 years, there's just no evidence that that has a deterrent effect on anyone ex ante. The other thing we know from research that's out there is spending more time in prison will not make you less likely to commit crimes when you come out. And in fact, we have evidence that goes in the opposite direction. So there's this big study in Texas where they found that for every additional year that somebody served incarcerated in Texas, there was a 4 to 7% increase in their recidivism risk. So again, when we get to the First Step Act, we want to think about, was there an assumption in the political process that longer sentences would be better? Yes. Does the evidence back that up when we're talking about deterrence? No. The other key thing might be, well, okay, but if someone's incarcerated for a longer period of time, they're incapacitated. And so you get a benefit for the period of time that they are incarcerated. They're not outside of the prison committing additional crimes. But what we know about that is since 95% of the people incarcerated will come back out, you have to weigh the increased risk of recidivism you're creating by keeping someone in longer because you're making it harder for them to adjust when they come back out again. And you have to take into account, would they even have committed additional crimes? So are you even getting an incapacitative benefit, or were they aging out of their crimes anyway? So you're just kind of keeping them in a facility when they wouldn't have done anything. So what we might want to do to figure out how to balance that is look at what actually happens when we lower sentences. Do we lose too much of a public safety benefit from incapacitation? Or, in fact, are we okay? So for the First Step Act, I think the most relevant data for us is what happened when we lowered sentences for people who were serving time for crack cocaine. The Sentencing Commission was able to follow those folks and look what happened 5 years afterwards. And you can see here, the retroactivity group is the group of people who got the sentencing reduction. And the comparison group, they served their full sentence, so they weren't able to get the benefit of the reduction, but they could be matched perfectly with the people who did get early release. And what you see is the recidivism rate for the group that got out earlier is lower. Now, I should mention that was not statistically significant that it's lower, but it is 100% statistically significant that it's not higher to do it. So you're not getting a recidivism risk increase by letting somebody out early. And that, one would have hoped, would have been front and center in the minds of Congress when it was debating aspects of the First Step Act. So a couple things about what the First Step Act did on sentencing. It did finally make the statutory changes to crack sentencing retroactive. So this was a change. What I'm showing you is what happened with some sentencing guideline reductions. The First Step Act finally made the statutory changes to crack sentencing retroactive, and that'll benefit about 3,000 people. And I think from this evidence, we can be pretty confident that we're going to see the same kind of recidivism rates. Therefore, we're not going to see an increased rate in this population. So that was kind of the good news of the First Step Act. The bad news is the First Step Act made a bunch of other changes going forward. So for those of you who practice in the federal system, you probably are aware of 924C. If you use a firearm during and in relation to a drug offense or a crime of violence, first time you do that, you get a 5-year sentence, mandatory minimum. Second time, it's 25 years. Third time, another 25 years. And previously, the Department of Justice interpreted that to mean even if you'd never been convicted before, but there were 3 buy and busts of you, you could get the first buy and bust would have been your 5 years, even if you hadn't been arrested in between. Second one, 25 years. Third one, another 25. So you could be a first-time offender looking at a 55-year mandatory minimum under the DOJ's interpretation. The First Step Act changed that and said, actually, from now on, let's make it so the first one means first time convicted, and then second time would be after that conviction. So that was an important and necessary fix, not retroactive. And again, we could ask, why not make it retroactive, given everything I was just saying about how we could do things like this without a public safety hit, particularly because you could have this go before a judge to make sure that under the facts of an individual case, it was okay to make the adjustment going backward. Congress couldn't get the political will to do it. Similarly, there were some changes to some other mandatory minimums. for your third drug offense, you won't get a mandatory life sentence anymore, but you will still get a mandatory 25 years. But again, you might ask, well, okay, can't you at least then give that relief? Now we've decided this is the right sentence. Shouldn't the folks who are serving the life sentences get relief? No, it's also not retroactive. And I think this evidence is the kind of thing that shows us why that's a mistake on the part of Congress, because it could be done without a public safety hit, but they didn't want to do it. The other thing that I think is important to keep in mind here is this very expensive to keep people incarcerated for a long time. Congress hasn't cared much about that, but in states that do, because they can't print money and run a deficit, they've paid more attention to the fact that sentencing is expensive. And so when we look at states that I think are doing a better job on this front, a couple things to note. First of all, they are able to, so the states with sentencing commissions have been able to stem the growth in their corrections budgets. And they've also been able to do the same in terms of their incarceration rates. And they have been able to do this without increasing their crime rates. So this, again, could all be done at the federal level as well. But unfortunately, Congress wasn't able politically to muster the strength to do it. The last thing I wanted to mention about the First Step Act and some assumptions behind Congress's thinking is with the mandatory Congress, we still have mandatory minimums all over the place in the federal system, and they really didn't change much except, like I said, going from life to 25 years. Mandatory minimums are a huge driver in the size of our federal prison. They're also big drivers at the state level as well, but since we're talking about the First Step Act, I limited my data to that. So you can see that that's a big chunk of who's currently incarcerated in the federal system. And Congress did so little to address this in the First Step Act. It made those minor changes I mentioned. It increased the safety valve eligibility very slightly, but that was it. And it's a real opportunity lost, unfortunately, because when we're talking about this population serving mandatory minimums, particularly for drug offenses, we're often talking about very small fries. So just to give you a sense, it's a little small font, but that's just designed to show you most of the people who are getting sentenced for these big drug sentences are low levels in drug conspiracies. They're not the kingpins, they're couriers, they're mules. They're forming very, very minor functions. And they also have very little criminal history category for most of them. So these are also not repeat offenders all over the place. In fact, almost half of the people serving drug mandatory minimums were in the lowest category of criminal history under the guidelines. So the talk, if you looked at the legislative discussion of the First Step Act, though, you were thinking that we were talking about El Chapo and we had to keep the sentences as high as possible. So they're very modest reforms, and I'm happy to talk more. I'm sure all of us are about it. And so what I just want to emphasize is the politics behind that. That was not a debate about public safety. That was just pure rhetoric based on assumptions that either the politicians themselves hold or they assume that their voters hold about the need to keep sentences really long, despite the fact that we have this evidence that they could be cut, they could be retroactively adjusted, and you wouldn't see those kind of sentencing increases. It's because of a political process that really doesn't spend time to rationally evaluate what we could be doing to better stem mass incarceration. So I'm going to put this in my shameless plug part because I just wrote a book on this. And so I have to tell you that the whole book is filled with examples like this of things we do that are completely counterproductive for public safety, that make us less safe and cost us a fortune. But we do it because we don't have systems in place that do a better job of rationally evaluating it. So that chart where we'll have to wait till 2100 to reduce our incarceration by half. I'm not even sure we'll get there because that assumes that we keep up our current pace of reforms. And I think we're one uptick in crime increase away from all that reverting. And so my recommendations really are to think far more about creating new institutional models that do evaluate data like this. Sentencing commissions, maybe not the federal one, it has some flaws, but even the federal one was able to reduce all the drug sentences for 30,000 people. You can't get that kind of big scale reform from legislatures because the politics just won't allow it. So I do think as we think about reform, we need to be thinking about institutional structures and changes, and I will stop there for time.
Thank you, Dean Barkow. And yes, see her book, buy her book, and she will sign it for you. Now we will move on to, and we will have an opportunity for question and answer, but these folks here are just so, such experts in their field. I wanted to give them an opportunity to give a long discussion about what they do so that we can follow up or come back around with questions. And so now we will come to Mr. Yarborough, who, again, was on the defense team for Mr. Brown, and I will let him tell you about his experience without trying to summarize it for him. Mr. Yarborough.
Thank you very much. First thing I want to do is give a shout out to a couple of pals I've got in the audience. Back there in the tan jacket is a fella named Ligon. Bill Ligon was a star basketball player for Vanderbilt University back in the day. And 39 years ago was named as one of Nashville's 12 most eligible bachelors. The afternoon paper, and the only reason I know that is I was also one of them. And I can tell you now that we're not only not eligible, may not even be bachelors. I don't know, Bill. You tell me. Yeah, you probably do. And over there to his left, my right, is Sonny Koshy, one of the finest trial lawyers in Nashville, Tennessee for many years. He's an assistant United States attorney for the Middle District, and he loves mandatory minimums. And if you want to know why they're good, go talk to Sonny, get the counterpoint to the previous presentation. All right, I just wanted to do that because I had the power to do it. Now, Cyntoia Brown is quite a story. How many of you have heard that name? All right, well, not as ubiquitous as we think here in Tennessee. Cyntoia Brown was born in Georgia, I believe in 1988, something like that. And she moved to Nashville. Her mother was said to have drunk a full bottle of gin or scotch every day of her life, practically. So Cyntoia Brown suffered from fetal alcohol syndrome, among other things. Her mother and father pretty much abandoned her before her 15th birthday. And by age 15, she was on the streets of Nashville as a prostitute, being marketed by a man who later died because of the street culture that we had in that part of town. But unfortunately, one night she was at a local fast food restaurant and got picked up by a man who took her to his home, and kind of an unconventional scene, and I'm not going to go into great detail here, but I'll just say that they ended up in his bed, and for whatever reason, we're never going to be completely sure, she became extremely nervous about what he had in mind, and she shot and killed him. She actually stated to the police at one point that she executed him, and that was part of the proof at the trial. You might think that case would never go to trial, given the background and who the victim was, but there was a great deal of interest in the case, and the DA at the time, who was in the room this morning, I don't see him this afternoon, I guess he knew I was going to be here. No, a really fine person. Torrey Johnson, the prosecutor at the time, is also a professor at Belmont Law School. And they just thought that that was a first-degree murder because there was some evidence of it being first-degree, in the sense that premeditation might have been formed in a moment, as the charge says in Tennessee, and also that it could have been a felony murder because she proceeded to steal things from the home and his automobile, which she later abandoned. So pretty bad crime, right? And won't go into, I hope, more detail than I should, and stop me if I get too long, please, Judge. But this case went to trial. She received a conviction of first-degree murder and a life sentence. In Tennessee, a life sentence is 60 years minimum before you're eligible for parole. However, we have a 15% good and honor time provision in our sentencing laws, so it really boils down to 51 years if you get all your credit. So there she was at 16 going into the federal prison system for 51 years. Now at that time, she was a handful, and she admits that. She was not very tolerant of any of that. And when she went to the prison, she got write-ups for a couple of years. And over time, however, in our state penitentiary for women, she began to see the light. And you can't really put your finger on any single factor, but I would say the collective wisdom of our correction system, coupled with an outstanding educational program from Lipscomb University here in Nashville, eventually bore great fruit in Cyntoia Brown and, frankly, several others. Very little known, but I actually had a client at the penitentiary named Michelle Martin who received clemency from Governor Haslam before Cyntoia did. But my first client, Michelle, had never met Kim Kardashian, so that never got in the paper. But Governor Haslam actually commuted 2 first-degree murder sentences I'm sorry, the first one was a second degree, commuted 2 murder sentences before he left office. One was Michelle Martin, and the second was Cyntoia Brown. So there she is. Now, I would say that the process between about 2010, give or take, and 2019, when she finally got clemency, was a grind. My partner, Charles Bone, saw a documentary on Cyntoia Brown and became very interested and very passionate in her case, and worked on that case for 8 years. When I got to the firm 5 years ago, I saw the file, asked about it, and he said, since I had this background in criminal justice, that maybe I'd help him out a little bit. So I assisted a little with the appeal to the Sixth Circuit on the federal habeas corpus, but none of the direct appeals or the post-conviction things were really ever going to work for her. So about a year and a half ago, maybe 2 years now, the application for clemency was filed. We actually got a hearing before the Tennessee Board of Pardon and Paroles, which most people don't get. That hearing lasted for the better part of the day, and primarily Charles Bone and Houston Gordon, a really fine trial lawyer in West Tennessee, put on a big show and made a strong impression on the board, because we had 2 board members that voted to commute to 15 years. We had 2 voted to commute 25, and we had 2 that voted to give no relief whatsoever. With that in our pocket, which made us feel kind of good, because usually people don't do too well at our board, we went to the governor's counsel, Dwight Tarwater, another outstanding lawyer whom I already knew, and began banging on his door. I was actually at a political fundraiser one night for someone who I think was here earlier in the day. Was David Briley here today? All right, well, we were raising money for David to continue to be the mayor of Nashville, and I got a call from Dwight and said, the governor wants to see you and Charles Bone tomorrow morning. Can you make it? And I can tell you, if we'd had an appointment with, Donald Trump, Vladimir Putin, it wouldn't have mattered who we had an appointment with the next morning. We were going to be in the governor's office. And we went up there and spent almost an hour with him. And his primary question was, we've got dozens of juveniles out there in a similar situation to Cyntoia Brown. Why should she get relief and the others not? A really good question. But we, I think, had an answer for that, and the answer was an incredible record of rehabilitation. She had finished almost all the coursework for a bachelor's degree with straight A's. She had had a religious conversion, and I think that was real, and I think it bore fruit at the prison in terms of her help with other inmates who she tutored and mentored when she was out there, and her write-up record disappeared. So all of that put together, and then something happened that I'll just allude to quickly. It did get into the social media arena somehow or another. People who were interested in calling this a human trafficking case, which frankly I never thought it was, but that's what happened. They got on the Facebook and the Twitter route, and LeBron James and Kim Kardashian and several others picked it up and sort of befriended her and it became a media event. Now, we were frankly really worried at that point because we thought that that was going to mean that the governor would have to show that he was not going to bow to all this celebrity interest to grant clemency for someone. But at this point now, in hindsight, and actually hindsight's next year, right, 2020. But yeah, that's just the way I am. I can't help myself. Yeah, thank you. And so we really think now that that might have helped us because it put some indirect pressure on the governor and his staff to do something because everybody knew about it. You know, a lot of these things are I mean, I never had a meeting with the governor on Michelle Martin. And so we put the hard press on and then had a second meeting with him where he described some terms that he might put on it and if he granted something. And the bottom line is he did commute her first-degree murder conviction to a second degree. She will serve 15 calendar years under that arrangement. She'll be on parole for 10 years, which comes to 25, the maximum for second degree. And Lord willing, she'll get out on August 7th of this year. So it was quite an emotional thing to go out to the prison and tell her that. She's now in the annex in the process of being trained to go out and be a free person. She's 31 years old. She doesn't have a driver's license. She's never had a checking account. There's a lot that has to be done there, but we're very confident that she is a mature woman now and not a 15-year-old prostitute, and she'll be fine, but there are going to be a lot of protections in place. So that's the inspiring story of Cyntoia Brown, and I'm sure you may have questions about it, and if we have time, I'm happy to answer.
Absolutely. Thank you, Mr. Yarborough. And information about the pleadings and some of the work that Mr. Yarborough and his partners did in Ms. Brown's case has been uploaded to the ABA website. So those pleadings are available for you to read them, and you should because they are most striking and moving if you have time to look at them. So I want to come back to a few questions before we open it up to the floor. We know that the Nixonian tough on crime mandates that began in the 70s and then under the Clinton era really exacerbated the mass incarceration rates. Prior to the Nixonian tough on crime mandates, we really had a rehabilitative criminal justice system or a justice system that was focused on rehabilitation. But those mandates really changed how we incarcerated people and what we were trying to do in terms of incarceration. And so I heard panelists before talk about the election process and how that affects states and incarceration rates. But we know that federal judges are appointed. And if you read articles, and federal judges don't talk to people much, but the few articles where the federal judges have done interviews, they will talk about the mandates and how that is so obstructive to what they would like to do in terms of criminal justice reform in their role as judges. So I want to ask Professor Hagan and Professor Dean Barkow, the First Step Act was some movement towards justice reform. But where do we really need to go? Because we know it's not really the judges. There are some judges who sentence harshly within the guidelines, and the federal guidelines are very interesting compared to state guidelines, where there are guidelines at the state level. But where do we really need to go in terms of the second step maybe, in terms of criminal justice reform? I'll start with Professor Hagan.
Well, that's a really important question. Thank you. Maybe one quick answer would be to say we need to go backwards. You don't usually have the opportunity to say that in a constructive way, but as you've pointed out, and to be a little bit more specific, as far back as we can trace rates of imprisonment in the United States from about 1900 up to about 1960, the rate of incarceration in this country remained very stable and very low. And so this is a contemporary phenomenon, and since it's occurred in most of our lifetimes, we're not so aware of that, and that's a really important point. Another point, I think, is that some of this has had to do with sentencing guidelines, and in particular states. And it's important to, again, realize that there was a long tradition in the United States from the beginning of this country up until we really got into sentencing guidelines in the latter part of the last century, where judges had pretty complete discretion in their sentencing, and it seemed to be helpful in terms of maintaining those low levels of incarceration. And the sentencing guideline movement had a lot of unintended consequences, to put it mildly. And so I think we just, in part, we need to have a better knowledge of our history. And then we need to know some of these kinds of statistics that are coming out in Professor Barkow's work that really underline the point that we are over-incarcerating in the sense of the proportionate reaction to risk that we're dealing with.
And I guess I would add just a couple things to that. So, next steps, things that I think we should do, I would say priority one is no more mandatory minimums. One of the reasons why the guidelines are as harsh as they are in the federal system is before the first Sentencing Commission even had a chance to write the guidelines, Congress passed a bunch of mandatory minimums. And the first Sentencing Commission made the decision that, well, I guess we'll build all of our guidelines around what Congress had just done with no research or evidence or analysis of whether they were a good idea. And in fact, when you go back and look at that legislative history, Congress really had in mind that they were setting mandatory minimums for kingpins and high-level traffickers. But as you could see from that slide I showed you, that's actually not who they're getting applied to. But never with any feedback from an agency that could report and tell them that, Congress just stepped in. And we've seen that time and time again in the federal system, where Congress wants to pass a sentencing law, doesn't wait to see what the analysis might be from the Sentencing Commission, and just goes ahead with it. And if you look at some of the areas that judges complain about the most in the federal system, behind those you will find congressional actions and directives that the agency just never had a chance to address. So I would say no more mandatory minimums. The other key thing I think that I would like to see going forward is we need retroactive fixes when we do finally get around to fixing our laws. And I do think that Mr. Yarborough's example of Cyntoia and her great rehabilitation is not unique in the sense that we have people that change over time. And if you know people in your own life who maybe when they were younger went through some rough phases, but change and mature, not everybody, but most people do, and we don't have good systems in place in the United States right now to recognize that change. Either the change in our own knowledge because we learn more about a drug or something that we thought was we panicked, or the change in individual people. So the federal system doesn't have second look mechanisms. There's no parole, and the clemency process at the presidential level also involves Kim Kardashian. Actually, she has been very active at the federal level too. But we need real clemency. We need to have a back end mechanism. So until Congress gets its act together, it's up to the president to put in some correctives when we see laws get changed and we recognize that people have changed. And then third, the other point I just want to highlight is the Bureau of Prisons does not do a great job offering programming and things that we know work to help people successfully reenter. There's a residential drug treatment program that there's an enormous waiting list to get on, and so you typically don't get it until you're nearing the end of your term. And if you're not an English speaker, you're probably not going to get into it at all because there's very few offered outside of with English, and very, very little other programming besides that. Now, the First Step Act aimed to correct some of that because another big section of that bill is a requirement that the Bureau of Prisons is supposed to create these risk needs assessment tools to figure out who in the Bureau of Prisons will either qualify as low or medium risk, with some populations ineligible according to Congress, which is, by the way, completely contrary to all the social science evidence that says what we really should be doing is doing all this for the highest risk populations. But politically, they said, well, let's find low and medium risk folks. And the Bureau of Prisons is then supposed to develop programming for them. So I think they have 6 months under the act to create the risk needs assessment tool. And then they have another few months after that to create the programming. And then they're supposed to report back and let Congress know how all that's going. But none of it's really funded. So, and we have an acting head of the Bureau of Prisons right now. And to my understanding, there has been no advancement on any of those fronts. But I would say in an ideal world, so I guess it would either be the first step really taking, or the second step would be you'd have to fund it, and you'd have to get really serious about what you offer people while they're incarcerated to get them ready. Because if you think of our prisons around the country, they are big, awful government programs that do not work, with enormously high recidivism rates, that we should really ask ourselves why we would bother putting anyone in there, because all you're getting is the incapacitation benefit, such as it is, with very little programming at many facilities. And so I think at the federal level, it would be good to do that too. And then I guess last footnote I'll just say is, while it's true, I just feel like it's important to, I know the federal system gives guidelines everywhere a bad rap, but they shouldn't, because we do have states that have guidelines, and most of the states that have had them have done a good job lowering their incarceration rates with them. They have been way more successful than the federal system. And even in states where the judges, there's no guidelines at all, where they still have that old discretionary model, their incarceration rates have gone up. So this is a political problem and not a agency, maybe an agency design problem, but it's much more about the politics that we see everywhere. Whether or not you have a discretionary system or a guideline system, there's just political dynamics that we need to get to the root of if we want to get better results.
Thank you, Dean Barkow. And I'll just say that everyone doesn't have a Kim Kardashian or a LeBron James in their, back pocket or their contact list. And so we know that more than 10 million cases occur in the state system when it comes to criminal cases, and maybe 75,000 in the federal system. So there's a huge disparity in what we're talking about. And the First Step Act really only involves a small number of all of the cases we're talking about if you add in the state systems. And when you look at the politics that Dean Barkow talked about, the appointed judges versus elected judges, I think there was some discussion earlier about, does that really matter? I had the opportunity to interview 33 judges in 2 states that have an appointed system and an elected system. And those judges in my state of Alabama most certainly said that, yes, the elected system does matter. And they are worried about having Willie Horton ads run against them about letting someone out, and then that person commits a crime. And so they're more hesitant to sentence lighter, whereas the Massachusetts judges, Massachusetts has one of the lowest incarceration rates in the country, are not as much concerned about that. And so coming back around to the federal system, where we know that we all don't have celebrities in our pocket, and we don't have people that can maybe go and make big asks for us of governors, I want to ask Mr. Yarbrough, what do we do as practitioners in this room? And what is our role in all of this when it comes to such a big question, and how do we effectively advocate for lower rates of incarceration in our country?
Well, I think I can keep my answer within 50 or 60 minutes. That's a huge question. And yesterday morning, I was out at the TBI headquarters speaking to a new class of Leadership Nashville on subjects like this. And my big point to them was simply better people in the system. The reason we had the guidelines supposedly was that the disparity from state to state and district to district in the federal system on sentences was so great that we had to make them uniform. And I think the dean is correct. We probably created a monster, and you were part of that at one time. Yeah, okay.
She's not responsible for what happened.
Not responsible. Okay, I'm not either. But I want to. I hope I'm not failing to answer the question, but I want to talk about one quick thing that's happening in Tennessee and a few other states. This business of a 51-year day-for-day minimum on a life sentence has come under scrutiny in a lot of states, particularly for juvenile offenders. And the dean is correct that these people, particularly juveniles, think about it. Juveniles are not little adults. They're undeveloped. They're children. And yes, they commit some horrific crimes, and many of them do need to be locked up, no doubt about it. But mentally and developmentally, they are different from adult offenders and need to be treated differently. And yet, once they are bound over from a juvenile court in Tennessee, they are treated as an adult in almost every possible way. So we're over time. Real quick, we're trying to change that in Tennessee in the legislature. We're having a really hard time, but there's a number of us on both sides of the aisle politically who are trying to get our Republican legislature to enact something to give some relief to juvenile offenders on that 51-year minimum. And I'm sorry I went long.
And I just want to ask for one, because the other panel went over a little longer. If we could have just 2 minutes for any questions from the audience.
What can they do? They're not going to come get you.
All right. Any question? Yes.
In the very beginning, you were talking about just the effect of just detaining someone has such an adverse. Was that this panel, right? Am I right panel? Okay, sorry. It's blurring together. It's Friday, guys.
It's all related.
And I know that the federal system on a bail system is very different than the state system. And I'm in Tennessee, so our state system is horrible. What would be your suggestion from your research and your from your background? What is the best possible approach to like a bail system that we could put into place either on the state level or changing of the federal system?
So I would say no cash bail. You know, there's no reason to make it tied to money. There's no evidence that that does any good of a job of predicting. You know, you just want people to show up to court, and you don't want them to commit violent acts while they're out. That's the two risks that we're trying to guard against. On the showing up to court, you get the best bang for your buck. People just don't remember. So reminders, electronic text, reminders, that does the best thing on the failure to appear front. Now, if you've got someone who has, 10 outstanding failure to appear notices, that's a different story. But for the vast majority of the folks we're talking about, they'll come back as long as you remind them. For the risk of offending while they're out, that should be a very small percentage of people that need to be detained that way. So I'd say, a good model right now that I would look at would be New Jersey, which got rid of cash bail. Is used. I know not everybody likes risk tools, but pretrial detention is about risk. So you're either going to use a tool or you're going to use the judge's intuitive tool, their own internal algorithm, and you get better outcomes when you use these risk tools. New Jersey has done that, and their pretrial detention rates have absolutely plummeted. One caveat, though, they have this unified court system there, so the chief judge in New Jersey can really make the judges comply because the chief judge has a lot of control over their professional placement and whatnot. So in states that don't have that, and I don't know what Tennessee has, it's a little trickier to get compliance. Kentucky's had a problem with trying to reform some of their pretrial detention with the judges. Actually, at first the judges went along, and then they started not to like it. So I would say you don't need to have cash bail for sure, and you can lower your pretrial detention rates in most states dramatically. You'll save money. You'll improve your public safety outcomes. The fear that everybody has is that one Willie Horton case that'll upend it, because there's not going to be a news story that, wow, by detaining all these people pre-trial, we've actually increased the risk of crime for all of us. That won't make the news, but that's actually true.
Well, thank you so much. I have three groups I want to thank. First, I want to thank the CJS Council for the resolution. I'll let you know, panelists, that there is a resolution tomorrow that they will discuss as it relates to sending to Congress relating to retroactivity. So the ABA CJS will do that. So give them a hand for that. And also to fund those portions of the First Step Act that will be helpful and beneficial. Second, I want to thank Professor Durbin and the CJS Council for the opportunity to serve as a Diversity and Inclusion Fellow. And this is a part of my requirement. I have to do a project as a Diversity and Inclusion Fellow. And so thank you for the opportunity to serve. It's been wonderful. Thank you. And thirdly, I would like to thank our panelists who are superstars, rock stars in their fields, and we just want to thank them. So please join me in thanking them.
Thank you.